The points for and against medical malpractice reform. First of all, the points for medical practice reform really started back in the late 70s and early 80s regarding scarcity, or at least a claim of scarcity, of doctors in rural areas and throughout Kansas, and the claims that these physicians were being put out of business and hospitals being put out of business because of skyrocketing litigation costs, whether that be their initial insurance premiums to get insurance coverage, or also having to make massive amounts of payouts. And involved with that was also this claim that there was runaway juries. In other words, that plaintiffs who weren't really that injured, but juries somehow believed that they were extremely injured, and therefore were getting massive verdicts that were unnecessary and causing harm to the general public. And the main argument with that was that the general public wasn't getting access to health care because doctors and hospitals were closing and leaving the state, but also that your own personal health insurance premiums were skyrocketing. After many years of study and much more clarification, a lot of laws were put in place called caps on non-economic damages, which means that pain and suffering, something that is very hard for a jury to quantify because there is not an economic calculation to determine those damages. Rather, it's more based on testimony of the plaintiffs and for a jury to make their own best judgment of how severely injured they are. Legislatures around the country decided that juries weren't smart enough to figure it out for themselves, and instead were imposing legislation that said, for example, here in Kansas, only $250,000 was enough to compensate a person for their pain and suffering. The problem with this is when you limit how much a jury can award a person with massive amounts of pain, suffering, disability, and those sorts of damages, you're most harming the people that have suffered the most. A very good example of this is we had a client in our office who was an 83-year-old woman. She was enjoying her retirement. She was a traveler. She traveled around the world. She was a farm lady from small town Kansas, and she just happened to get in an auto accident, went to the emergency room for normal treatment, and instead of following the procedures they were supposed to protect her spine, they didn't. And what ended up happening is she became paralyzed from the neck down, and is now, instead of a world traveler, she's stuck in a small town health facility receiving 24-hour care, not even allowed to live independently anymore. And because of how legislatures have determined that juries can't figure damages anymore, she's capped out at $250,000 for a lifetime of being stuck in a facility rather than being able to live her life the way she wanted to. That is injustice, and that is a very strong argument for why damage caps are inappropriate, and why we as a law firm not only do our duty to represent our clients in a courtroom, but also at the state legislature, because we have to do best for our clients in their personal case, as well as at the legislative level. And we fight for you all the time to do that.